Let's talk more action. Former President Mbeki tells ANC members. Former President Thabo Mbeki told members of ANC in the Free State to start acting as opposed to talking. Mbeki said the era of having endless discussions in the ANC were over, adding the implementation of party policies needed to take center stage. To regain voter support, we must move from talk to action. As a province, we need to be judged by what we do, not just what we say. The very important part of winning back the support of the population, which in the last elections moved away from the ANC, to win back the support is going to depend on what we do, not what we say, he added. Mbeki was addressing the provincial PSC lekgotla held in Welkom over the weekend on what the organization needed to do in order to regain its lost ground in the last elections. He encouraged party employees who were in government that they needed to make sure that they implemented policies of the organization and deliver what they promised to the people. The institution of government must indeed respond in terms of the good of service in respect of government. The ANC Free State ANC meets to thoroughly assess the progress and status of the organization. Mbeki addressed the fundamental and uncompromising principles of unity and renewal, principles that are crucial to the survival of the revolutionary struggle. These ideals are not optional. They are the very foundations upon which the ANC must stand to lead our people to genuine progress. Delivering this declaration, Provincial Secretary Polediso Motsoeneng said the ANC carried an extraordinary obligation to purge itself of the characters who were the proponents of the counter-revolution masquerading as genuine members of the organization. Motsoeneng said they do so to secure the ideals of the democratic revolution. We also affirmed that central to tasks we faced, being the restoration of the ANC, act as the principal center of the progressive forces. We believe that a need for a consultative conference to deeply self-reflect as a revolutionary force and to assert ourselves firmly in the revolutionary path that we have to travel, the Motsoeneng said. Motsoeneng concluded by saying there was a need for the organization to have a concrete plan in order to drive the renewal and unity of the ANC. On the other hand, finding apartheid-era killers, legal costs a travesty of justice, by Dr. Reneva Fori. Every so often, the brutality of our past returns to haunt us. A harrowing example of the barbarism of the apartheid security forces that has recently surfaced in the assassination of the Craddock Four. In 1985, anti-apartheid activists Matthew Goniwe, Sparrow Nkonto, Fort Calata and Sicelo Mhlauli, collectively called the Craddock Four, were abducted and murdered. Their mutilated, charred bodies were found days later, scattered in various locations along the Eastern Cape coastline. It is distressing that the unmasking of the details of their murders is being postponed due to the quibbling over legal costs. Exposing the truth and upholding justice appears complementary, yet have been rendered complicated within the legal system of South Africa. Unraveling the exact consequence of events leading to the murders of the four freedom fighters is essential for reaching closure and preserving historical accuracy. However, it will require a financial burden on the taxpayer. The initial inquest conducted by the apartheid state in 1987 concluded that the Murdoch Four met their demise at the hands of unknown individuals, resulting in no prosecutions. A subsequent inquest in 1993 confirmed the culpability of the police in the deaths of the Craddock Four. However, the specific circumstances of their demise and the identities of the perpetrators remained ambiguous, and again, no legal action was taken. In 1999, 6 former police officers associated with the apprehension and killing of the Craddock Four appeared before the Amnesty Committee of the Truth and Reconciliation Commission (TRC), yet none of them obtained amnesty as they failed to make full disclosure. The third inquest, originally scheduled to commence at the Eastern Cape Division of the High Court in Gqeberha from September 2nd to 20th this year, has been postponed to June 2025. The adjournment is attributed in part to the legal representatives of former police and army witnesses, citing inadequate preparation time and the inability to secure state funding for the legal fees of their clients, namely Eugene de Kock, Isaac Engerbrecht, Christopher van der Vensuzen, and Craig Williamson, aged between 75 and 88. The National Prosecuting Authority (NPA) has expressed a willingness to provide financial coverage for the legal expenses. Many are asking, however, if it is adequately justifiable that taxpayers finance the legal defense of the apartheid-era killers, more particularly those who did not even bother to apply for amnesty. The financial burden emanates from the protection provided by the sunset clauses agreed to as part of the negotiation settlement. In these regards, Paulo Jordan, 1992, stated, "The central components of the state are in coercive arms, the army, police, laws and prisons, and its persuasive arm, the civil administration, civil service, and the state ideological apparatus." It is precisely these organs that we are now being told should not be tampered with, so as to enable the liberation movement and the regime to ride blissfully into the sunset together. The provision of legal financial support for individuals associated with the perpetration of egregious apartheid atrocities is tantamount to denying the apartheid victims the justice they deserve. It places an unfair burden on the taxpayers to uncover the truth. In so doing, it neglects to unfold the fundamental principles of justice as the perpetrators are escaping liability. The unfairness is causing many to relive the trauma of the past. The pain is compounded by the travesty emanating from an inadequate process led by the TRC. The TRC held public hearings post the democratic transition as part of the restorative justice effort to give apartheid victims a platform to share their experiences and allow perpetrators to confess and apologize. The cost of revealing the truth was amnesty, which also meant sacrificing justice, and sadly, justice is being sacrificed again. Regrettably, the poor management of the Craddock Four inquest is not an isolated incident. There are numerous cases where justice for victims is delayed due to the legal wrangling over fees. The COSAS 4 case involving Eustace Bimbo Madikela, Mtingo Matabane, Fanyana Nhlapo, and Sandisiele Musi is another stark example of perpetrators evading accountability by claiming they cannot afford the legal costs. In other instances, such as those related to corruption, the government has adopted a stringent approach towards the settlement of fees. The question arises about why there should be a divergent set of regulations for individuals implicated in apartheid crimes. This is a gross injustice that should stir our collective indignations. Furthermore, the TRC found 300 instances where the security services either killed individuals in custody or illegal detention centers like Flag Plus and assassinated them in the field through their infamous death squads. It advised the NPA to investigate the 300 cases and prosecute those responsible. Unfortunately, the recommendations have not been fully acted upon, and many perpetrators were never even identified, let alone brought to justice. The Nzebeza report for NPA and TRC prosecutions 2024 confirms that the NPA has failed in its mandate. The unfinished business of the TRC and the arrangements at Codesa place more emphasis on the rights of apartheid criminals than the rights of victims and their families. Frustrations have reached levels whereby family members have resorted to camping outside the Constitutional Court. Certainly, it is time to consider revisiting some of the Codesa arrangements and reviewing the legislation to guarantee justice for victims. It is imperative that the national dialogue discuss the matters. The delay in justice for the victims of apartheid strengthens the barriers to achieving reconciliation. Nation building and social coordination requires us to unearth and process the skeletons of our past. This includes holding the perpetrators of the heinous crimes accountable and ensuring they take responsibility, including financial responsibility for their actions. Only by doing so can our nation fully recover from the deep wounds of our past and reach its full potential. It is unacceptable that 30 years on, justice for the victims is fast fading into the sunset while the perpetrators are getting off scot-free. Dr. Reneva Fori is a policy analyst specializing in governance, development, and security. The views expressed in this video do not necessarily reflect the views of IOL or independent media. And that's it from Egypt's Network. Stay tuned towards celebrity and gossip news.